Good evening. How are you? Well, the temperature here was 94 today, and you could hardly move in it. And it was quite oppressive. And there was nobody walking or riding on the roads. And tomorrow, which is now Saturday, because I'm up early, the temperature is supposed to hit 100 here. And so, as hardy as I may think I am, and as resilient as I believe I am, I think one has to be careful about such heat. The mistake of so many people should inform our judgment. So make the same kind of judgment yourself. So I don't know if you can see me in the moonlight or my silhouette, but this proves my other point. I don't know what Thomas Jefferson would think of this. There's only one comment I want to make, and it's about Judge Loose Cannon in Florida. And it's the overarching question, which is, how do we get into this situation in which judges apparently, as gently as possible, reprimanded her for her continuous control of the case, suggesting that she should step aside and let another judge handle it, more senior, more experienced. And I wonder if in those conversations, the remnants of which we're getting from the New York Times as a result of good reportage in the Florida area, I wonder if they also said to her, we're concerned about your bias. And I've been involved in these motions before, and obviously the more enlightened and ethical judicial officers recognize if you call a conflict to their attention. And the law is pretty clear that it is either a conflict, or it appears to be a conflict, or could interfere with your judgment. But as a judicial officer, you should also be a person who knows that they're in over their depth. That great American philosopher, Clint Eastwood, said a man ought to know his limitations. So too a woman. But instead, we have to credit her bias because we have too many data points, as I like to say, when we have the evidence. The receipts is what we say on TV these days. And the receipts are what she did when this was about the search and how she sought to compromise any review of the evidence seized at Mar-a-Lago, and apparently was not even disturbed by the fact that the former president of the United States had interfered and obstructed justice, meaning hid boxes and moved them around like a two-bit thief. So we have these things. But why did nobody do anything? Why didn't the judge get in front of the courthouse and say, we've asked her to step down? Why didn't they invoke the judicial conference and ask her to step aside? Why didn't our special counsel, our prosecutor, act upon what he already knew from what happened in court with the search warrant? Why wasn't there a motion to recuse? In that same courthouse, I made several motions to remove judges, seriatim as we say, one by one after another, because each gave me legitimate objective concerns that they would not be fair and impartial, and that we were entitled to that. And we didn't have that. And they did. They did step back. Now, that was state court. The laws are similar. The practice is been with us a long time. We all know what it is, but they didn't act upon it. So why didn't our special counsel, who is long on the teeth when it comes to the experience of litigation and tough issues, why didn't he act? And it's ironic that the motion that is before the judge is about the question of the prosecutor's authority to have the power he does, and to receive the funding he's received to do his job. But keep in mind that part of the answer to that by the Department of Justice and by the special counsel is that the Attorney General oversees his work and in the end approves it or not. Now, we had the embarrassment and corruption of Barr when he was Attorney General, altering the report of Mueller and declaring what it said in violation and contradiction of what it truly did say and what it really did mean. So now we have an Attorney General, Garland. Tell me what your guess is was the conversation between our Attorney General and special counsel on the question of moving to recuse a judge, a brotherhood and sisterhood of which our Attorney General once participated as a judge himself. So there's a lot to go around, but the thing that strikes me is the cowardice in the face of offense to use the tools that are provided in constitutions and law and history and ethics that are ignored. As parents, on some really basic level, we understand that if a child does something, we tell them that they should not do it, instruct them how they should do it, and then find punishments, minor ones. Stand in a corner, you can't go out, you can't have your phone, whatever it is that works. But for adults, the same people who raise children, when confronted with the miscreants and the misconduct and the contemptibility of a former president, a judge, and others, to do nothing. Doing nothing is what gets nations and governments in trouble, compromises their ability to persist, to do the jobs that we think they should have. So, those are a few of my thoughts on this moonlit night, and I'm glad I've had this opportunity to talk to you. And tomorrow, perhaps we'll do it in the daylight, but maybe not if it's 100. So, thanks for listening. Talk to you. Bye-bye.